Okay, so I want to start. We're going to talk today about guardianship and how to avoid them. And really, the second part is the most important part. But I want to lay out kind of my biases before we start, because I think that's always important. We all have biases. My bias is guardianship is a measure of last resort. To steal from my partner who is on the call here, guardianships are reactive, not proactive. So I think it's good you know that. So I'm going to talk about all the ways that I try to avoid a guardianship. Just so everybody has some context, the firm does all kinds of guardianships. A lot of my guardianships are children with disabilities, autism, turning 18. And I personally believe, and not everybody agrees with me, that we overdo those guardianships. We do them and we don't explore other options. And that's a little bit what I want to talk about today is, can we look at lesser restrictive alternatives, look at some of these other things, and have an open mind of what these disabled individuals can do. So I wanted to get that out of the way. Now I'm going to talk about guardianship. So we'll start a little bit with a guardianship primer. One of the problems that I run into whenever I talk about guardianship is I like to talk about the new law. And I think my notes actually say the law was changed in 2022. So it's now 4 years old. That's not the new law. But in 2022, we switched from 1188 to 11130. And there have been some kind of major sea changes in some ways. In some ways, it's just different terms. And in some ways, it's similar and maybe even arguably in a little bit inferior in others. And it just depends what you're looking at. I think we have a lot more flexibility. One of the big things that the statute talks about all the time is that we want to maintain people's independence as much as possible. So to me, that's a big change. Under 1188, it just seems like everybody got a guardianship. I think under 11130, it's a higher standard of who we should be doing these for. So that out of the way. We'll start off with some common terms. This is a lot of the change. And some of this, you guys know what the RCW and the WACs are, so I'm not going to go into that. One of the big changes is we used to have guardian ad litem. The guardian ad litem is still mentioned in the statute. One of the things in a previous life, I worked for a city and I did a little bit of ordinance drafting. So one of my pet peeves is how statutes are not internally consistent, and 11130 is not. And it mentions guardian ad litem and defines it as being in a minor guardianship, which is fine, and it's in the minorship guardian section. There is a section in the statute that talks about guardian ad litem and seems to infer that a guardian ad litem can be appointed for a disabled individual, and it's different than the respondent attorney. I've never seen that used. I don't know why you would use it. It's unclear to me why that's even there, but it does exist. So what used to be the guardian ad litem is now the court visitor. I tell everybody, basically, that's the third-party court investigator, even though it's going to be a third party. It's going to be somebody who contracts with the court who may be an attorney or may not be an attorney. Their job is to do the investigation and make a recommendation that generally the court's going to follow. When you file a petition for guardianship, the person you're filing it on is called a respondent until a guardianship is appointed, and then it switches to an individual. So one of the things that I will admit I've tripped up on once or twice, and I think this is in my mind because my paralegal corrected me yesterday, I did one that I had it still listed as respondent. I never changed my caption to say individual, and that's technically not right because they had a guardianship in this case. So always important to pay attention and make sure you get the terminology correct. As I said, Washington law basically says that when you turn 18, people become an adult. We can all debate if that's a good idea. My position is I'd raise that level a little bit. But while people are legally competent, there are some people who are not going to be able to make their own decisions. And that's who are the people that may need a guardianship or conservatorship. And just to back up a second, that was the other big change under the law. I think this one was for the worse. We used to have guardian of the person, which was healthcare decisions, those kind of things, and guardianship of the estate, which was money. That's really pretty straightforward. They changed it to guardianship, which is now former guardianship of the person, and conservatorship, which is now the money. I think that's a little less intuitive. I think for a lot of the pro se individuals, it gets confusing. I'm going to tell you right now, when I'm talking, I'm just going to say guardianship. I kind of mean both. So just be aware of that. The law is pretty interesting that it sets out all kinds of topics. One of them is 11-130-001. It says the intent of the legislature is to protect the liberty and autonomy of all people and enable them to exercise their rights under the law to the maximum extent they're capable of being able to do that. The legislature also says in that section, the legislature recognizes that people with incapacities have unique abilities and needs, and some people with incapacities cannot exercise their rights or provide for their basic needs without the help of a guardian. So be aware. Then it says, however, their liberty and autonomy should be restricted through a guardianship conservatorship only to the minimum extent necessary to adequately provide for their own health, safety, or to manage their finances. So I take that as kind of my marching order that we're looking, and the statute does say this, and we will get to this, we're looking to give them some help, but we're not looking just to take away their rights. And one of the things I see, and I did practice under the old statute 1188, is it seemed to be everybody got a full guardianship conservatorship if you kind of asked for one. I don't think that's the approach we should be taking again. That is my bias. I think we should be looking, and it's in the statute, what is the least restrictive alternative. Amy is back.
Hi, Jim. Nice to see
Hello.
you again.
Good to see you again.
Somebody has requested information regarding the slideshow because they're not able to see the slideshow.
Okay.
I'm double checking. I thought you hadn't started it yet, but I'm just verifying.
No, I let me see if I can screen share. I was not
if
planning
not,
on that.
I do have the slideshow available to screen share if need be.
Okay, so I'll put this up. Is that now working?
Yes, it is working now.
Okay, this is where I am not the most technology savvy person, so let me just make sure I'm doing this right, because you're seeing more of my notes than the actual thing here. So let me move it down here. I thought you'd rather look at, there we go. So that, okay, is that now, are we now seeing that?
Yes, I am seeing.
Okay. Are you seeing the black screen with my title card?
Yes.
Okay. All right. So I'm going to try to get to where we sort of were. Okay. And I follow this, but I also bop around a little bit. Okay. So getting back to where we were. Yes.
We have several more folks that just popped in a moment ago. I just wanted to let them know that I have allowed them to speak if they need to. Just unmute yourself, ask questions, interact. If you feel like you want to have me read your question instead, then pop that into the Q&A. All right. Okay. Thank you, Jim.
No problem. Okay. So one of the big things in this world that becomes a little bit of an issue is outside of the legal community, people seem to think that it's doctors that deem somebody incapacitated. And that is not the case. The statute is very clear that you have capacity until a court says otherwise. One of the things that I've seen happen sometimes, and I had an issue with recently, was the facility the person was living in says, oh, no, the doctor deemed him incapacitated. You cannot speak to him. You cannot talk to him. He can be shut off and kind of closed off from the world. Allegedly, I don't really know what was going on. I never got the facts. It was hard to even meet with my client because somebody was trying to keep the world away from him. That alone is a red flag. That also is a violation of guardianship law. As we'll see today, you can't really restrict people's socialization without a court. Well, you cannot do it without a court order, and the court's not overly jumping up and down to do that unless you can show actual harm. So I absolutely do have guardianship orders where we've restricted contact with certain people, but that's usually an abuser or a financial abuser, not just we don't like so-and-so, they're doing something wrong. I've seen this in the context of the 18-year-olds where somebody's trying to file a guardianship because the disabled individual has a significant other of whatever sex they are, and this person is difficult and causing problems, and that's not something the court's going to do. I have seen where parents are filing it against, you've got the 18-year-old young man, the 20-year-old woman, and they think she's taking advantage of him. That's going to be a difficult thing to do outside of if you can show actual abuse. Now, if you switch it and it's somebody who is financially abusing, the court may be very willing to do that. As I said, if you look at 11-130-265-3, as it says, termination of incapacity is a legal, not medical decision based upon, and I underline this, demonstrated inability to manage things. And one of the things that I always want to be aware of, age, eccentricity, poverty, and medical diagnosis alone do not justify a finding of legal incapacity. I also want to tell everybody, and I mean this slightly tongue-in-cheek, and if you've been here the whole time, I'm a little bit silly with some of this stuff, but I think you can take a lot of people and twist their lives to look like maybe they don't have capacity. So I'll throw myself a little bit under the bus. I don't dust real well, so there's sometimes dust in my apartment. I once had somebody, believe it or not, file a guardianship against a parent because they found a frozen pizza box in their garbage and said, well, they're not getting sufficient nutrition, so we need to do this. That, of course, wasn't the real reason. The real reason is I don't like who's the power of attorney and I want control. But I have seen kind of crazy circumstances. One of the things I tell everybody is there are a lot of eccentric people out there. And that alone, if just because you don't fit in society's box doesn't mean you should get a guardianship. I once met with somebody that was very, very interesting to me, and I've met with multiple people. A lot of people have some disabilities that they make up stories, and it's hard to tell what's real and what's not real. One gentleman, and I was court visitor at this time, was telling me about how he was a pilot and he ended up in the hospital because he crashed his airplane at Boeing Field, and that was why he was in the hospital. He had a really bad visitor for this because I'm a pilot too. I could look him up on all the FAA databases. I could look him up in the NTSB database and look for crashes at Boeing Field. I think I probably would have heard of him. And that was all a figment of his imagination. I had somebody else I met with who the stories sounded a little outlandish, but they would start to ring true at times. So just because you're eccentric and have 130 cats in your house is not alone the reason for a guardianship. Now, it could, because you've got 130 cats and your house is a disaster. But I'm always very wary of, I think if you use language and you're good at, you can find a reason that most of us have issues. So I'm not going to pick on anybody, but there's lots of them out there. So I think the court needs to be wary of this. We already talked about the change of terminology, so I'll skip that one. Okay. What is a guardianship/conservatorship? When somebody has a disability and they can't handle their personal, which is healthcare, or financial affairs, the powers to make those decisions are removed and placed in the hands of a guardian or conservator. As I said before, there must be a disability, not just really bad choices. So one of the things our firm does is there is a clinic, I'm a little bit pitching this, clinic at Tacoma Pro Bono on Tuesdays called Aging Options. And it's kind of a heartbreaking thing to do sometimes because people come in and says, well, my son has some PTSD. He's living on the street. I want to get a guardianship so I can get him off drugs. And I think that is probably a valid reason to do it. But as I try to explain, the court's not going to, take his drugs away and make him do that. And well, maybe it helps get him some treatment. You're not going to be able to force somebody to move in off the street just because you have a guardianship. It does require demonstrated harm, but in my position, court doesn't always read that the same way I would, because I see many cases where a guardianship is signed off for an 18-year-old with a disability simply because they have autism and we're giving them a disability. One of the big things with this is the court is the super guardian. They retain jurisdiction. And when I'm talking to lay people, I tell everybody, you're going to talk to the court every year or every 3 years because you're going to be doing reports. And there is a lot of documentation under the new law. Okay, as I said, there is a three-pronged test for guardianship. That's 11-130-265. Number one of that test is the respondent basically lacks the ability to meet their essential requirements for physical health, safety, or self-care because the respondent is unable to receive or evaluate information or communicate decisions, even with technological support or assistance. So number one, and this is usually the easiest one to prove, there is a disability. So it's often very common that this one's easy and clear. One of the things that I warn everybody to warn their clients is when you file that petition and you are signing, you may be on the hook for all the fees. So my law partner is on here. I'm going to use her as an example. She decides, Jim is really not competent anymore, and I'm going to file a guardianship. She files that guardianship with the court. And then we end up in a situation where the court says, no, Jim's fine. He's competent. It is possible that Liz could have fees, costs, and costs of the visitor assessed to her because it was not well-brought petition. So always warn your clients in the statute, there is some liability here. The second part of this is the appointment is necessary to prevent a significant risk of harm to the adult's physical health, safety, or self-care. So where this comes into play is the nursing home isn't going to get paid, so they're going to get kicked out. Somebody is stealing their money and they don't even understand that. Or I have met people in facilities that I come in and say, so what? Hello again.
Hi, Jim. Finish your thought, please.
Okay. I have people who come in and, tell me, oh, I know where my money is. It's at X, not at X, it's at Y. I once went to visit somebody in a facility and they had a stack of paper and they pulled out the statement for the bank account. I'm like, well, at least we know that one. And maybe there is some understanding of what's going on. But there are a lot of people who think they're paying their bills or not, or say they are and they're just not doing that. So that would be a significant risk of harm. Amy, go ahead.
Okay, so the question is this statutory definition applicable in AIP, where incapacity is alleged more generally and the WIP is now deceased?
So read the question again. I'm not tracking.
Okay, is this statutory definition applicable in AIP, where incapacity is alleged more generally and the WIP is now deceased?
That was my question.
Oh,
Jim.
okay, thanks.
Shannon. I'm sorry. I had sticky fingers here trying to eat lunch and listen at the same time. What I was wondering is that while you're going through these statutory definitions related to incapacity, could they be used in a TEDRA where, for instance, the person, not a guardianship proceeding, but for instance, the person has now died and we're talking about the past?
In theory, I guess. The problem is this 11-130 requires a finding of incapacity. So I get the vibe you're saying, like somebody's ripped off and stolen all the money and now they have died and you found out about it and you're messing around in TEDRA. I would say you could try to argue it. I think that's up to the judicial officer to make that determination. I know that the VAPO statute is wildly different in what who is able to get a protection order. I have had both argued against me in TEDRAs. The VAPO one, I think, is a little bit wild. I think at that point, you just need to provide medical records that this person is incapacitated and allow the court to determine that because they're no longer alive. So there's never going to be a finding of incapacity. It's just, did they understand what was going on? And I think that's unfortunately a pretty high burden and a hard thing to prove sometimes because the person taking advantage of them is isolating them. You can't get medical records. It's real hard to get medical records after death. So I think it's worth an argument. I get frustrated when people try to argue the VAPO language and that alone is enough for a TEDRA. I don't think that's true because I think that's like over 60 years old. And not everybody over 60 is incapacitated. But this is for finding of incapacity under 11-130. I thought you were doing something else. I thought you were asking about attorney-in-fact situations when you've got a power of attorney. And I think you could reference this standard if you want your powers of attorney and say, the person is deemed incapacitated under 11130 or meets the standard 11130. I think every one of us does it differently on how we do our powers of attorney. So I don't know if that answers your question or just confuses you more, but.
It does. Thank you.
Okay. All right. Then we have the most important part of the statute, I think, which is the respondent's needs cannot be met by a protective arrangement instead of guardianship or a less restrictive alternative. So that is the big part that we're going to kind of talk about today. And there are probably protective orders. There are other protective arrangements. This gives you a lot of creativity in a guardianship that we're trying to accomplish something, and maybe there's other ways to accomplish it rather than a guardianship. Because one of the things I haven't mentioned and isn't in the slides is guardianship is a little bit unique in that we revoke people's rights. And I think we need to be really thoughtful when we do that. If you do a power of attorney, you still have all your rights. That goes back to the argument I was having with the facility that, well, they've been found incapacitated under power of attorney. They don't have any rights. And I'm like, you need to talk to your lawyer. You have no clue what you're talking about. That is not the law. I see that sometimes. Actually, I've seen that with banks and financial planners. Well, they can't access their account because they're incapacitated. And I'm like, how have they been found incapacitated? Well, I've got a doctor letter. And I'm like, well, that might trigger a power of attorney coming into place, but that is not a determination of incapacity because only the court can do that. Amy, you're still here. So do we have more questions?
We do.
Okay.
Yes. How many people can there be as an guardian? Can there be multiple?
So that's up to the court. I don't like having multiple, but I have had in disabled individuals where mom and dad are both appointed. I try to counsel them against that because my fear in those situations is, if say you've got two co-conservators, let's do it that way. The bank could say, we're not allowing transactions unless both parties agree to that. And I don't think anybody on here will be surprised to hear my frustration in all areas of the law I do is there's the RCW and there's the WACs. And then there's these made up rules that the bank dreams up every morning to make life more difficult. One that happened recently is a client of the firm's goes to a bank. They've got their order appointing guardian and conservator, and they've got their letters of office. And the bank says, no, we need an affidavit. I'm like, no such thing under the law. Those are your two controlling documents. I have seen banks jump through hoops to not give people access. So it's very important to realize you've got somebody who's kind of, I don't know if I can say they're operating extrajudicially, but the person you're dealing with isn't necessarily going to always follow what Washington law says. I'm convinced some of these banks, well, I'm convinced these banks don't really have legal departments. They have like one paralegal in Utah. And I know just because I used to practice in a different state that one of our local banks practice in, I think they use the state law from the state they're aware of. So they know, California law, and they think every state's the same, which is not the case. So as far as co-guardian, you can absolutely have one person as guardian and one person as conservator. That may make sense because you may have somebody who's very good at care, but couldn't manage money out of a paper bag. But I don't love having co-agents, but the court's absolutely done them here in Pierce County. Most of the time it's mom and dad. This morning was in King County, and there were co-guardians and they were fighting it out. And that's my fear, is anytime you have two people, one goes off and does things, doesn't keep the other one informed, and now they're all frustrated. So yes, you can do it. I think it's bad practice. But if you want one person as guardian, one person as conservator, that could make a whole lot of sense. I also explore that when I talk about powers of attorney, because I use kind of my family as an example. I'm an attorney. My brother is a drug dealer. Okay, pharmacist, but same thing. So when we were doing stuff for my mom, I'm the person to do the finances because I understand that stuff. My brother's a little less educated, but me doing healthcare is scary. Like when I joked earlier that you could say, this guy needs a guardianship, I avoid doctor visits like the plague. Typical guy thing to do and really dumb probably, but I don't like doing it because I don't really understand what they're talking about some of the time. And I feel like I'm a reasonably intelligent human. So in our case, power of attorney for finances me. Power of attorney for health is my brother. Now, the other factor that floats around out there is he lives with my mom. So when you're exploring doing lesser restrictive alternatives, I think it's always a very good idea to ask a lot of questions and say, you know, don't just name child one because they're the oldest. Who is the right person to do this job? I love it when my clients come in and they've got like a nurse or a doctor in the family because, well, we know who's going to do healthcare decisions now because that is the person who's educated. So one of the things when I do these, I talk about is I think as estate planners and attorneys in general, we spend a lot of time on our wills and trusts, and often the powers of attorney are kind of this like throw in last minute thing. And I think we need to explore those a lot more with our clients than we do, because the clients just think, oh, it's something. Like, how many clients have told you, well, my power of attorney is good? Well, they're dead. It's no longer valid, because everybody thinks once you got a power of attorney, you're good forever. Not the law at all. One of the things we talk about, because we are court visitors, respondent attorneys, and see TEDRA work, is I would say the biggest, well, I don't know if the biggest abuse of elders is their children or people under a power of attorney. Those flip-flop back and forth. But I see power of attorneys are used all the time to help sell to money that shouldn't be done. And as Ms. Jones was kind of hinting at or suggesting, you now have a TEDRA come across your desk, the person has died, and the child who had all the money has spent it all, and it's all gone, and now we've got a problem because something improper has happened, and you've got to spend all this money in court to maybe get the money back. And even if you get a judgment, you're going to get the funds back. So I think that one of the things we need to think about, and I would like to see a little more restriction on, is how powers of attorney are dealt with and treated in the outside world. And I think that would make the banks happier, because banks, there's actually a process under the power of attorney statute of how you reject a power of attorney. And I've never had a bank try to do it right. They just say, no good, done. And that's not the way it is. So I always tell everybody, spend some time on your powers of attorney and make sure your clients understand. And it may go in one ear and out the other, but at least try to explain, this is a very powerful document. This allows somebody to act for you. And you don't just name your eldest child because your eldest child is your eldest child. Name the person who is best set up to do that. And that might be the person who's closest. It might be the person you live with. Maybe the person you live with is great at your healthcare, but terrible at money. So always look at this. Now, getting back. So as I said, and I've sort of hinted at what one of the big lesser restrictive alternatives is powers of attorney. They're very useful, and I do them a lot for disabled individuals so we can avoid a guardianship. Okay, who needs a guardianship? And I've lost my cursor, so I'm in big trouble here. Number one, there is no law anywhere that says somebody with disabilities or somebody who's incapacitated must have a guardianship. I have a lot of individuals who are disabled who live their whole lives without a benefit of a guardianship. And I would say the more disabled you are, the less you may need for a guardianship. And as I said, some of my bias is dealing with the 18-year-olds. But when somebody comes to me and says, I have a child turning 18, they're never outside my sight. They pretty much can't get out of the house. I start wondering, what is the harm? What are they going to do? As opposed to the individual who might be substantially higher functioning, who's going to the mall or going to the AT&T store and signing up all these contracts because they like signing things. Or I once had that. The mall kind of dates me because I've never even stepped foot into Como Mall. I have no idea what's inside there. I just remember back in the 90s, there were all the kiosks that sell you aluminum siding. And I once had a disabled individual who was under guardianship sign one of those. And that's a voidable contract. I also was court visitor in a case where the young man would call realtors and try to list his parents' house for sale quite regularly. I also used to represent a client that the individual would call Social Security and report the guardian conservator rep payee dead 3-4 times a year just because they didn't want this. So sometimes when you've got a disabled individual who is substantially higher functioning, it's going to be a much harder job under the guardianship and conservatorship. So considerations. One of the big ones that I always want to think about when we're dealing with elders especially is how will the loss of autonomy affect an individual? I have absolutely had guardianships where you've got somebody who has enough capacity to sort of understand what's going on, but isn't taking care of things. And they get so angry at their child for filing a guardianship against them because you're taking away my rights or you're throwing me in a home or all these things that people can think. So I think you do need to balance that. I have had some clients, especially when it's a spouse, that they are very worried that if they move forward with the guardianship, their spouse is going to be very angry with them and therefore they don't want to choose that. I've had that where it's kids where, dad has been independent his whole life. He's still driving even though he shouldn't. And what are we going to do about him doing that? And my war story for this, and this one's amazing, and makes me wonder if this guy would even qualify for a guardianship under 11130. Dad is driving to the mall, and it's not Tacoma Mall, different mall, leaving his car there, then calling the cops because he walked around the mall and then the kid stole his car because he forgot where his car was. So the kid took his keys away. And then he decided, well, you took my keys away. I still got my checkbook and my phone. I can call a taxi and go buy another car. So as somebody who's on the roads, that was a little bit scary. As somebody who's an attorney, I'm thinking, I think this guy might not be making great decisions, but probably still has some capacity. The other consideration I always ask with guardianships is, why are we doing this now? What is happening that is causing this? And again, I'm going to repeat the statement I made earlier. Guardianships are reactive, not proactive. So I get a little frustrated when the answer is, well, they're turning 18 in a few days. We need this guardianship. But what problems are you having? With the elderly, it's a lot easier because if somebody was fine and then crashed their motorcycle and now has a brain injury, that has changed their whole life. Or you had somebody who's been living at home, who shouldn't have been living at home, is now in a facility, and you're starting to pull back the curtain and they have not taken care of things. Their house is in foreclosure. They haven't been paying their mortgage. They haven't been paying their bills. Those are absolutely good reasons to be doing that. But I always ask that question. The big problem with guardianships and conservatives, it takes time and it takes money. And I guess I'll talk about this now. Basically, what the law says is when you file a guardianship, you're supposed to have it done within 60 days. You can extend that. Sometimes it does not happen, and I will explain later the reason for that, but it does take some time. There are two kinds of emergency guardianships. There is an emergency guardianship that can move a little bit faster than 60 days, and there's an immediate emergency guardianship that I kind of hate because it will appoint a guardian without even notification to the respondent. Basically what happens is you go in, ex parte appoints a guardianship, then you have to give a notice and get an attorney appointed. And I have real due process problems with that. If you have somebody who's lost rights, even if temporarily, based upon a verified petition of an individual who may be telling the truth and it may be necessary or may be lying. And the problem I have with that is, what is an emergency? Like if they're walking down Tacoma Ave, throwing their money to everybody on the sidewalk naked, maybe that's a reason. But it's just, well, we can't pay the nursing home. That's a traditional normal guardianship. You've got to work through the process. As I said, and what we're going to talk about today, there need to be alternatives. Look at the alternatives. Don't just say guardianship should never be the first tool in your quiver. It should be your last tool in the quiver. It is a personal family decision. Common reasons. Big one is for elderly people, you've got some demonstrated harm. They're not paying their home, or not paying their facility. They're not paying their bills. They've got a foreclosure on their house. I have learned, and this is my biggest surprise, if you don't pay your sewer bills, the county is brutal with sewers. If you don't pay your bill, you're going to get a foreclosure against you. Like, just don't pay your taxes. You can go years, but don't pay your sewer for 6 months and they're going to have a case with you. They're not paying your bills. You're overdrawing your account. Like, there's a lot of financial reasons why you need to look for a conservatorship. You need to move somebody to a facility. That can be an interesting one. This is from a prior life, but I once had somebody who was clearly incapacitated, but was one of the best actresses I'd ever seen. And she could play a competent person for about 45 minutes to an hour, and then would start divulging and cycling. And when the kids tried to put her into a facility, she's like, my kids are trying to steal my estate. And the facility said, we're out of here. Until we've got a court order, we're not doing anything with this. Contact with the legal system is one. If you've got a victim or perpetrator, maybe that's something you need to look at. And then for my youngins and adults, the big one is we can't make medical decisions for them because we're not a party. Now, we'll talk about a statute that does exist in the next slide. So there is a priority of who can make decisions for a disabled person, but there is also HIPAA law. And our friends at the facilities love to quote HIPAA. I am not a constitutional scholar, so I'm not going to get into the argument of what law controls, but HIPAA has been thrown in my face many times. The new one I am learning is insurance is becoming a problem. Insurance will not talk to the 21-year-old parent whose insurance they're on, and insurance absolutely is not going to talk to the 56-year-old child when mom isn't doing so well. So that's another reason. Passport is on here just because it drives me crazy. In case you don't know, for the most part, the federal government doesn't recognize state guardianships, except when they do. And my partner had an issue with them not allowing somebody to get a passport and said, you need a guardianship. So I absolutely love that well, we don't really recognize your guardianships, except we do this time. So there are other reasons you may need it for a disabled individual. And I'm still frustrated. Since she's on here, I can say that I'm still frustrated. I think she got this all wrapped up like within 3 days and lords it over me all the time because my guardianships take, 50, 60 days. But that's, I guess, why she's better than me. Okay,